happens when life occurs, people die, get divorced, etc. And the assumption is that when you form an LLC in a given state, that state's LLC statute will govern, the operation of that and has a default playbook. And that's unfortunately not the case. It may govern 20% of the issues that you may encounter as a member of an LLC, and even those 20% are typically not the result you would hope for. The other 80%, there's no rules offered, no default rules. So when you get into a situation that requires, you deal with some issues, there's nowhere to turn.
And that's state by state, you said, correct? Every state has its own LLC laws?
Every state has its own LLC statute. A lot of states have kind of a similar statute, kind of a form statute that has common rules, etc. So there's not a lot of differences. There's a few nuances, but there's no state I've seen that has kind of a complete playbook. It's very, very minimal. Kind of the nice thing about the LLC is it's a blank slate, but that's also the issue with the LLC is you've got to determine what rules to put in place. And if you don't, as we'll be talking about today, lots of bad stuff can happen.
Yeah, it's a bit of a double-edged sword. Lots of flexibility, but also lots of gray area that has to be interpreted in the courts if it's not written down and it becomes a problem. And I hit the record button a little bit late on this. I'm going to go back and introduce you again. Talking with Brian Burt, partner with Snell Wilmer. And you, of course, are a business attorney, also a merger and acquisition attorney, which is a specialty among business attorneys. And so you, Brian, get involved in the entire life cycle of a business from startup until termination, correct?
That's correct.
Yep. And today we're talking about operating agreements. That is the document that helps set how the rules are going to work, especially when there are partners. And I think, Brian, one of the questions that the people, or one of the things that people seem to maybe not quite grasp is when it's a one-man shop or a one-woman shop, and they don't have some of those things put together, like an operating agreement, they might keep it off to the side. I'll get to that later because it's just them. What are some of the concerns that you as the attorney would have when someone has not done that from the get-go, from day one?
Yeah, even if it's just a single member, you should have one in place for a variety of reasons. But the main reason is it helps round out your corporate shield. So the main reason you form a company is to make sure your personal assets are protected against creditors, disgruntled customers, former employees, etc. And so filing the articles or certificate with the state to form the LLC is step one. But then the operating agreement has the appropriate terms and conditions, even if it's just a single member. And it's easy to do. It's a short form, doesn't require a lot of effort, very inexpensive to put together. It's not something you file with the state, but it's going to be appropriate for, again, rounding out your corporate shield. And you're going to get requested to provide that document in a number of places. When you open bank accounts, someone comes in to fund the company, you sign up for certain services, etc., maybe at least a space, people are going to say, hey, show us your governing documents, and you want to have that available.
Yeah, fantastic. Yeah, thank you for that. Now, with partners, with two business owners, it makes more sense that people would want to have something written, but even that doesn't happen as well. And, worst case, what I think about is a 50-50 ownership between two partners with no operating agreement. You, again, are the legal expert in this area. What do you see as potential disasters that can easily be avoided when they give the time and attention to the operating agreement that really needs to be there?
Sure. Well, I have yet to encounter a company where the partners did not disagree at some point along the life cycle. I've yet to see it. And some of those disagreements are just business disagreements, right? How to expand the company, where to, new products they want to launch, etc. But oftentimes it's more than that. Or, as I mentioned a couple minutes ago, it's kind of life happens, right? Someone decides they need to exit the company, or someone breaches whatever agreements they had, etc. And if there's no playbook in place, it's just total chaos, right? There's really no way for anybody to kind of step in and easily resolve this. It ends up in a big fight, may end up in a lawsuit. It often kills the company. And so kind of putting that playbook in place, whether it's a 50-50, which sounds great in theory, until you disagree on something. And the minute you do, where do you go? If you disagree on a business issue, there's no way a court, an arbitrator decides a business issue because there's no right or wrong, right? It's just a question of what business direction to take. If it's something else and someone supposedly did something wrong or wants to, leave the company and there's an impact again, where do you turn for the rules? It's not going to be typically in the state statute, so you're stuck. And again, people start fighting about it. We see it all the time. It's one of the top causes of litigation, one of the top reasons that companies go under, and totally preventable, as you said, by putting in place the playbook, but doing so ideally before the company's even started, when you're just kind of in concept stage, the founders are coming together, figuring out who's going to contribute what. Best time to do it, because once you wait, there's a good chance, and we've seen a number of examples, just a couple recently, you and I were talking about, where they don't do that, and then one person gets thrown off the team because the other people decide, well, we don't need you anymore. And so if there's no agreement in place, again, it's going to be a tough fight to demonstrate what the partners were supposed to be doing.
Yeah, that makes a lot of sense. Here in Arizona, it's pretty easy to get online and to file the papers, and boom, you're in business, you have an LLC. But when you go through those steps, obviously I don't remember anything that speaks to an operating agreement or no option to get one. So as far as I can recall anyway, there isn't anything that really says, hey, stop it before you get this started, get that operating agreement in place, go see somebody, get it done. So that leaves it wide open to what you're describing, that people just don't get there. There's another way, though, that people will get sometimes documents, Brian, like online documents as something. And of course, that can add some value, but I caution against online documents like that, because there's no substitute for having a Brian Burt here and having his years of expertise and his opinion on your particular situation. There just isn't a substitute for that.
Yeah, we love when people use kind of online services, because our litigators need to feed their kids too. So those documents that are put together are really generic. They often are not state specific. They certainly don't cover the landscape of issues. It's usually very kind of templated format. And the operating agreement is one of the more complicated documents that I draft in my practice, because it really is tailored to the individuals that run the company and what they want. And I've yet to see two identical situations. Maybe they have a certain approach to contributing capital to the company. Maybe they have a certain vesting of their ownership. So if someone leaves, they give back some ownership. Maybe it's a certain situation as to, when they can jump out of the company and get redeemed out. So there's a whole host of issues that they need to think through, and kind of getting a generic form, like you say, it could be better than nothing, but sometimes it gives, as we've seen, a false sense of security. Hey, we've got something in place, we're good to go. We assume it's kind of standard form, and then again, one of these issues arise, and they say, "Wow, we didn't contemplate that." Well, that's because you got to kind of go through the process and think through, what are our expectations, and get those on paper, get them detailed. When an issue arises, you pull that out of the drawer, and you know exactly what direction you're going.
Yeah, and let me just repeat what you just said, because you made a point that I think is often misunderstood. People get an operating agreement, say, off the shelf, and they think they've got one, I'm good. When in fact, what you said is you're tailoring your document specific to the owners, the members of that LLC, maybe specific to what they're trying to get out of that business and what their goals are. And so you really have to understand who those members of the LLC are to draft that appropriately for them, correct?
That's right. And if you haven't done it before, which if you're just a first timer, or even if you've done it 2 or 3 times, but you never been through the process, getting a form, again, just plugging in percentages and, hey, we're good to go is what you see a lot. And that doesn't deal with all the nuances. There's probably 20, 30 issues, situations that we talk through with the client and say, hey, what happens in this circumstance? Let's say you die. Is it a situation where your spouse comes in or your kids come in and kind of take over, or do they become more passive owners, or do they get bought out? What if the other party decides that, I've got to go do something else, or I'm bored, or whatever the reason is, and they jump off? Do you get to take some of the equity back, or do they get to keep that equity? That can create lots of issues. What happens if somebody does bad stuff and there's a breach? Can you expel that member, get them out of the company, and on what terms does that happen? So just, management, what happens if there's a deadlock in a 50-50 deal? How does that deadlock get broken without killing the company? So there's just a whole host of issues that you really got to talk through and say, what if this happened? No one likes to think about that because they're excited. Right. start the company, get going, and this kind of falls to the wayside.
Right. Now that makes sense. So there's an option when you start an LLC, whether it's going to be member managed or whether it's going to be manager managed. And I think that's also a point of confusion. Can you speak to that, how that really affects things?
Yeah, I typically default to manager managed. It kind of sets it up so there's a board of managers. It might just be one, similar to a board of directors in a company. It may just be one director, but it sets up a more typical structure. So as the company kind of grows, and you may want to bring in other participants, either as a manager or as as an owner, you have that structure in place. So the members are the owners. The board of managers would be those kind of governing, on that level. And then you have your day-to-day participants. You may have, just like corporations, officers and so forth. But I think the manager-managed approach lends itself more easily to expansion and growth, investment of capital, et cetera. So that's, unless there's a real reason not to do that, and I've rarely seen it, I think that's the best way to go.
Okay. And then Brian, often when a business starts, sometimes they have a very clear idea what they're going to do. Sometimes, businesses change. So they might start out producing X and end up doing Y because that's just how the business evolved. With that operating agreement, maybe on day one they got together with you and put one together, but then the whole business has changed. Maybe the model has changed. Would that tell them, or would that say to you, let's go back and revisit that agreement and make it current with what you're doing today?
Yeah, I think with any agreement you put together can get dated. A few years back, the LLC statute in Arizona was rewritten. And so to the extent that you didn't refresh your operating agreement, now you've got an agreement, if you have one at all, that refers to the old statute. And there's some notable differences between the two. So I think it's always good, maybe on an annual basis or so, to kind of get a refresh. And maybe you're good. Maybe to your point, the business has changed. Maybe participation has changed. Someone dropped out. Different people have stepped up in a managerial role. Maybe you're going to be bringing on capital. So I think it's always good, maybe on an annual basis, just to get a little refresh of where the rules may have changed, your business plan may have changed, your participants may have changed. And, does that necessitate some tweaks to the operating agreement or a revised version if it's appropriate?
Yeah, no, that makes sense. Yeah, people's lives changed, people's families changed, businesses changed. So keeping those documents current, of course, makes a lot of sense. Some of the common things that you see, even when somebody has an operating agreement, maybe somebody else drafted it, they come to you and there's some kind of an issue they're trying to resolve. What are some of the common areas in the operating agreement that maybe they get neglected or ignored and they really shouldn't?
Yeah, I mean, we could talk for a long time on that. I think the key ones would be, they don't put in place the appropriate, because an LLC is a very tax-driven entity, typically set up as in tax as a partnership if you have more than one member. And so you've got to account for those issues. And so people will give out units instead of shares. They're units in the LLC, and they'll give them out. Some will pay for those. Some will have kind of what we call service units, sweat equity units. And if you don't set those things up properly, it can have a really nasty, unexpected tax impact to some of the members. So people just kind of give things out and not really think through or understand those tax issues. And that can be, again, a very unpleasant surprise. I think creating appropriate management structure, who's going to be making the decisions on a day-to-day basis, what decisions have to go to that board of managers level, what decisions have to go to the members, and who gets to vote on what, and how do you circumvent or deal with deadlocks if that arises. People dying, right? Figuring out what happens there. Again, does a spouse step in and control the voting of those units, or do they buy that spouse out? What happens if people get divorced? Very common, unfortunately. And do you have a mechanism in there to buy out the ex-spouse if they get awarded some units? I think the biggest one we probably see is that people don't put together a vesting schedule to key it to what contributions are getting made. So you'll have different people lining up at the beginning or along the way and saying, I'm going to contribute X, I'm going to build the software product, or I'm going to put in so many hours for business development, or whatever the contribution is. And in my experience, oftentimes at least one of the members just doesn't do it, either because they got lazy or they decide they need a day job or whatever the reason is, right? They just don't live up to that. You need to have something in place to be able to adjust the ownership. If they don't do anything, then take back those units. Otherwise, and we've seen it many times, you have very unhappy surviving members who say, gosh, the guy over here has 30%, we can't get it back. And now we're working full time. He's over here doing something else, and it just creates a lot of issues. So having a vesting schedule and a kind of a result if someone decides not to do what they say they're going to do, which happens very frequently, is a good way to ensure people are happy.
Okay, thank you. And you mentioned a moment ago about selling. Maybe one partner wants to sell, maybe one doesn't want to sell, and then a way to resolve. So if it is a 50-50 ownership in an operating agreement, what kind of, I guess the question I'm trying to get to is how would you resolve that? When it's 50-50, it's
That's
not clear how you resolve when they're butting heads on something.
I mean, if it's a 50-50 and you can't agree, then there's a couple of options, but the most common option is what we call kind of a buy-sell. And some people think the buy-sell is the whole operating agreement, and that's really just one piece to deal with the situation you're talking about. And the buy-sell, often you have a shotgun buy-sell, which is one of the terms that's used. And it's essentially where one party, one partner, one 50% owner can come to the other and say, you know what, I'll buy you out for X. And then that partner receives the offer and says, well, that sounds good. Go ahead and buy me out. Or I get to turn the tables and buy you out for that price. And so it sets up this dynamic, and I call it kind of the nuclear option. I've only seen it exercised 2 or 3 times in my career because it encourages people to come to the table and figure it out, as opposed to the uncertainty of not knowing, hey, am I going to be standing as an owner or not? I don't know, because if I make the offer, he could turn the tables or vice versa. That's really the only way to do it, other than just a couple other options. That's the most common. Another option is to have a put right, where one member can come to the other and says, hey, I'm out. You got to buy me out, and here are the terms, typically over a period of years, pursuant to a note, etc. Again, people aren't as excited about that because the partner could just come to you at any time and say, I'm out, and now what does the company do?
Yeah.
Not cash available to do it. It puts a lot of strain on it. The resources are disappearing from that partner. So there's not a great way to navigate that other than those provisions. But the best way, as you mentioned a few minutes ago, is just to align those expectations at the beginning, right? Are we in this for the next 20 years, and this is what we're going to do full time, or is this a part-time thing we're going to get started and then kind of sell it in 5 years, or are we going to run it and maybe pass it to the next generation? Kind of aligning those expectations up front can avoid a lot of those headaches down the road when one person all of a sudden wakes up and says, hey, we haven't talked about this, but I think I want to leave now.
Right. And when it is 2 partners and they're very similar in age, very similar with their family situation, then it's presumably easier for them to make decisions and kind of walk in lockstep together. But when there's an age difference between those 2 owners, and one is now close to retirement, or one gets divorced, or one's been single his whole life, when there are those kind of differences, then it can certainly set up the stage where more likely there might be some disagreements on what they would like to do going forward.
Oh, absolutely. I mean, we've seen a situation where 2 families came together to form a company and ran it for decades. And then literally one woke up and said, hey, I think it's time to sell. We need to cash out. The other one said, wait a minute, this was supposed to be a generational business. What do you mean sell? And literally been in business for 20 years and never talked about it. So to your point, I think whether you're similar age, but certainly if there's a difference and one person may retire much sooner than the other, I think you need to sit down again, ideally at inception, before you start putting in effort and time and money, and say, hey, what are we looking to get out of this? And I think people sometimes are surprised by the people they brought to the table. They think they're in it for the long term when they're really not. It's hey, I'm here for 5 years. Let's grow it. Let's sell it. Let's cash out, and I'm going to go do something else. And it's good to know that up front. And may or may not be a good partner in terms of meeting expectations. And you may end up finding, someone else who's a little bit more aligned.
Yeah. Yep. So we've talked a lot, Brian, about inception and what should go into the document in inception. But as you and I both know, a lot of folks already have LLCs. They've had it for a very long time, and they have not had someone like you with your expertise look at it, given what that company's doing today, given what the members are doing today and what they're trying to get to. Somebody who's in that boat, and they really want to have that looked at, say, by you. You've mentioned before to me that you have a, I forget the term you call it, some kind of an audit. I forget the term that you use, where you'll take a look at things for people, the broader picture for them and their business. What is that term that you call it? I don't remember.
Yeah, yeah. So typically we'll do a legal audit. So that's the
Legal
right
audit.
term. Yeah, kind of come in and say, hey, send us whether it's the operating agreement and or other documents you've kind of been using, and we'll look at that. And typically it's free of charge, and we'll kind of go through and say, hey, based on where you're at today and what you're trying to accomplish in the in the coming years, you're either good to go, which great, nothing to do, or here's some things you need to think about. Maybe when you started, it was very simple, and now there's all these other participants, and you need to update this to reflect the holes or the things that you're not doing correctly, or maybe the rules have changed from a legal standpoint, and you're not reflecting those. The tax rules have changed, and so yeah, happy to always chat with folks, and it doesn't take long. It's you can we're doing this long enough. You can kind of take a look at the agreement and know pretty quickly, hey, this is in pretty good shape, or you know what, there's probably 5 or 6 or 10 issues that you just haven't contemplated. You may want to address those before it gets to the point where, folks are fighting, or there's disagreements, or there's life events, and you haven't thought it through.
Yeah, thank you for that. So Brian, I don't know, anything that we haven't touched on? We touched on a lot, so thank you for that. Any key points that we haven't touched on that you think the listeners should really hear about in their operating agreement?
Yeah, I think the maybe one of the final things to mention is we see a lot of folks saying, hey, I'm going into business, or I'm in business with longtime friend or a family member, and you know what, we've always gotten along so far, so we're not going to exert the energy or the expense to kind of get things baked into an operating agreement. And I can tell you from lots of experience that those are the nastiest disputes that we see. And people just don't seem to understand that. They say, well, we'll work it out, and you got all the business issues, and then layered on top of that is all the family issues or the friendship issues, and it just breaks those relationships apart. And we've seen 40-year friends hate each other after that. We've seen family members sue each other, whether it's parent and kid or it's whatever. It really gets to be unfortunate. And again, if you have the playbook in place, as we've been talking about today, and one of these issues comes up, you just pull it out of the drawer and you say, okay, when this happened, we agreed this would be the result. Okay. And one party may not be as excited because they maybe hope for something different, and maybe they sit down and negotiate a different outcome. But if they can agree, they said, yeah, we did agree 5 years ago or 10 years ago, this is what we're going to do, and so we'll stick to that. Or legally you have to stick to it because that's what you signed up for. So I think that's a big takeaway, that no matter how close relationship or how well you know them, or if it's a family member, even more important to maybe that's counterintuitive, but more important to get that in place, because those can get pretty nasty.
Yeah, excellent advice, Brian. Thank you so much for that. If somebody'd like to talk with you or reach out to you, what's the best way to get a hold of you? Is that an email address, to your website? How should somebody get a hold of you?
Yeah, always happy to chat. The email is probably the best way. So that's B-U-R-T, so bburt at swlaw.com. So bburt at swlaw.com. Great way to get in touch. Happy to chat with anybody. Again, free of charge, to kind of talk through their operating agreement, or one that they think they might want to put together, and see how we can help.
Yeah. Thank you, Brian. I'm going to repeat the word he said, free. So make sure that people understand that, you can take a quick look and look at, you can find some obvious things maybe, or at least give them some time, which is very generous of you. Thank you for that. And this is such an important document that people just don't give enough time to. So thank you for the time that we've had here today. And we'll get your email address on the notes down below. So if folks have questions, they can reach out to you directly. So thank you so much, Brian. Really appreciate it.
Thanks for having me. Great to be here.
All right. Okay. Bye now.